everyone. Do I get everybody's attention? Sorry, thank you. Greg unfortunately is not here today. He had to be out of town. My name is Mark Levine. I'm the tax manager at Chapman Hex. So I'm going to be introducing everyone today, our speakers. I just want to thank everyone for coming to the Aspire event. We really appreciate this, you coming out and being a part of everything that we do here. As you know, Chapman Hex has been around for 27 years, providing our services to the community, from tax planning to financial advising and everything like that. And we appreciate all of our clients and our friends that come and help every day to make our business what it is. And we appreciate when they show us that how we do and what we do for them by giving us referrals to help people that they know. So if there's anybody out there that that could use our help, whether it be from tax planning to helping with financial situations, we really appreciate it if you come reaching out to myself, Greg, or anyone on the management team to let us know anybody that you may know that needs our help in any way. As you know, you have the handouts in front of you for the CPE evaluation. So afterwards, if you can just fill those out and provide them to either JC or Andrea out front, it'd be really appreciated. As always, the videos that we take for these will be up on our website, along with all the prior Aspire events that we've had. First, I'd like to, before introducing our speaker, I'd like to introduce Becky Aguilar. She's a director of the Dallas Children's Advocacy Center here in Dallas. For those of you who don't know, we like to bring in some nonprofits to speak before the event so that you can get a little bit more information for some of the things that are going on in our community. Here's Becky to tell you about her nonprofit.
Thank you, Mark. Good morning. How's everybody? Is it cold enough in here for you guys? Keep us all awake. Well, thank you so much for having me here this morning. My name is Becky Aguilar. I'm the Director of Community Engagement at the Dallas Children's Advocacy Center. How many of you have ever heard of us before? Wonderful. That's great news. It's pretty common for us to get out into the community, and unfortunately, unless someone has needed our services, they may not have ever heard of what we do. We are the only agency of our kind that serves these kids in Dallas County, and what we do is coordinate the investigation and prosecution of criminal child abuse. CACs are located all over the U.S. and all through the state of Texas. We have the privilege of being a national leader on education on child abuse topics here in Dallas County. We have an amazing center. The information that I've put in front of you really talks about all of the ways that you guys can help get involved in this community issue. Child abuse, as we know, it touches every single race, ethnicity, religion. Every single zip code in Dallas County is a zip code that we serve. We see families every day that come from all over the Metroplex. And we need the community support to make sure that we're able to provide these life-changing services to these kiddos and their families. More than 80% of the kids, probably closer to 90% of the children that we see come in because they've been a victim of sexual abuse by someone that they know and they trust. And I'm sure most of us grew up learning about stranger danger and teaching our kiddos about stranger danger. And that's important, and that does happen. But what we've learned through the years is that most often these children are truly victimized by someone who has had the opportunity to get to know them. They care about these kids. These kiddos care about them. That's the grooming process. And then it becomes a slippery slope into how these kiddos are manipulated into keeping a secret and keeping this very traumatic event to themselves. So when our kiddos are brave enough to come forward and tell somebody what's been happening to them, they get sent to us at DCAC. We partner with about 30 different community organizations, so that's 27 local law enforcement agencies, the Dallas County District Attorney's Office, Children's Health and Medical City are our medical partners, and we work with Child Protective Services. We have an amazing 56,000 square foot facility in East Dallas, right off of I-30. It's a quick 10-minute drive from downtown. And all of those partner agencies are in our building. We have someone from the DA's office. We have Dallas PD. We have CPS right in our building. And so what that allows us to do is be kind of that hub for a family to come in. A child can tell their story in a safe, child-friendly environment to professionals that understand child development. It's kid-friendly the way a child is interviewed. And then after that, we can assess their level of trauma and get them mental health treatment through our clinically trained trauma-based therapy services at our center. Every single thing that a family receives from DCAC, from counseling services, a forensic interview, any kind of financial assistance that they need. We provide backpacks upcoming. Really strange to talk about Christmas in September, but that's the next thing on our plate. And so we're going to have 2,000 children that are going to need Christmas gifts, and were it not for what the community provides, these kids would go without Christmas. And so everything that we provide at DCAC is free to these families because of the support of our community and folks like you and organizations like yours. So really what I'm here today to tell you about is that we would love for you to come to the center. I give tours. I've toured a couple of people here. Mr. Terry Bennett has been on our board. He can get you connected to me to set up those tours if you're interested in more information. And let's talk about how we can get your companies and your social groups and yourselves involved in this cause. Children are definitely our most precious asset. We all know that they are the most vulnerable victims and they need the most help. And so this is a really great way to get you guys plugged in. We're printing up really great boxes. You can do toy drives at your offices. It's a super easy thing. I'm sure everyone in here has someone that goes to Target once a week to buy things. Throw an extra Barbie doll in that basket. Throw an extra pack of diapers in. Those are needs that go directly to children here in Dallas County. Thank you so much for having me. I will take a couple of questions. I know I'm on a tight timeline, but does anyone have questions? Nothing?
Just let me add one thing. I will tell you that if you go on a tour of this place, it will impact your life. And I really believe that. It will impact your life. Take your spouse, take your kids.
Absolutely.
I mean, your kids will be impressed by it as well. So it will make a difference.
Yeah. Thank you so much, Terry. Again, Terry is on our board and he has my personal contact information. Our volunteer email address is on this flyer as well, so there's tons of ways you can reach out to us and get connected. I would love to personally give every single one of you a tour if you're interested. It's my favorite part of my job is talking about the center. So thank you so much for having me. And if you need anything, please feel free to reach out.
Thank you, Becky. Now I'm going to introduce our speaker for the presentation. It's Brandan Mohammadi. Brandan is an associate attorney at Locklord LLP in Dallas and is a member of the firm's nationally recognized privacy and cybersecurity group and incident response team. He earned his law degree from the University of Texas of Law and is a member of the State Bar of Texas, Dallas Bar Association, and has several other professional affiliations. He's going to be presenting on cybersecurity and privacy this morning, so please help us in welcoming Brandan.
Thank you, Mark. Thank you all for being here this morning and taking the time. And thank you to Chapman and Hex for allowing me to come and speak at Aspire. As he said, my name is Brandan Mohammadi. I'm with Locklord. For anyone who don't know, it's an international full-service law firm. I have two areas of my personal practice. I do the traditional commercial litigation as well as privacy and cybersecurity. I'm here today to talk about the latter, the privacy and cybersecurity issues. If you have dealt with this stuff day in and day out as part of your career, especially in a specific area, then a lot of what I talk about today is going to be fundamental. And the goal today is to talk about what the regulations that you need to be aware of are for anyone aspiring to be a CFO or in the C-suite, as well as some best practices and common mistakes made in a breach response. I have a lot of material up here. I may skip through some of it at times to make sure we get through all of the basics. But if you have any questions, don't hesitate to ask, either during the presentation or after. So whenever we're talking about privacy and cybersecurity, a lot of people use the terms interchangeably. How I see it is cybersecurity is the technical side. It is the means of protecting whatever the information at issue is, whether it's healthcare information, personal information, depending on the regime you're under, denotes the term you'll use to refer to that information. Whereas privacy is the right of the consumer or the individual or the data subject for that information to be kept private. So you'll see through the regulations that there's been a trend over the years for a consumer's information to be owned by the consumer, whereas historically it was viewed by owned as the company that collected it or the company that processed it. It was owned by that company. Well, you're seeing through these regulations and the rules they're enacting that the view is skewing towards the individual or the data subject being the true owner of that information, and the entity is the custodian that has certain kind of rights to this information, but has obligations to the data subject or the individual who it collected from. So obviously I can't go through all of the state laws, I can't go through all of the regulations. I'm going to touch on some of the key ones with a kind of focus towards some financial industry regulations. Mainly talk about the scope as opposed to the technical requirements. You have in front of you a cheat sheet for the New York DFS regulation. I have another cheat sheet as well that was, the cheat sheet version is too long to print it out and hand it out, but it compares the big three of Hipaa, New York DFS, and Gdpr in much more detail in kind of a 12 or 13 page cheat sheet. So if you want that, feel free to reach out and we can provide that to you. As far as the ones we're going to just touch on today, the first is Hipaa. Hipaa is one of the first modern privacy regulations and one that probably most people are familiar with and run into on a day-to-day basis. Hipaa is the reason that whenever you go to the doctor, the information that you provide is kept confidential. HIPAA's a industry-specific regulation, which I'll contrast to other types of regulation in a minute. Another industry-specific regulation is the GLBA, which was a few years after Hipaa. The New York Department of Financial Services is also a industry-specific financial regulation, but it's more localized, at least for now, and we'll talk about how it may become more widespread in the near future. And then the GDPR is not a industry-specific regulation. The GDPR applies, well, I should backtrack a bit. The GDPR is a EU regulation that applies far beyond the borders of the EU. And it is not industry-specific. It applies to essentially all commercial entities that have certain ties or connections or presences within the EU. And then on the other end of the spectrum of the broad, expansive scope of the GDPR, we have certain state laws. There is no overarching GDPR equivalent in the US. There is no federal privacy regulation that's not otherwise industry specific. So for a lot of the more general privacy laws, you have to look to the states. And so we'll discuss those a little bit as we go through here. So to start, Hipaa, one of the original privacy laws, I'll go through this very, very quickly. As the internet was coming into its own, stuff was being transmitted more electronically, people realized that how accessible and freely information and health information particularly were being exchanged was a real problem. So they enacted Hipaa that had certain protections in it, and those protections expanded over time. I think the final omnibus rule for Hipaa/high-tech was 2013. High-tech is much less recognizable than Hipaa, and the reality is high-tech was a expansion or an arm of Hipaa. So most people simply just refer to Hipaa of the joint requirements of Hipaa kind of as amended and supplemented by high-tech.
Brandon, could you speak up a little bit? There's some people back there who have a hard time hearing.
Yes, sorry about that. I'll speak up.
You might want to move the mic up a little bit.
Well, the mic's just for the video, I think. And the scope of Hipaa is to distinguish between covered entities and business associates. Covered entities are, in essence, the primary target, if you will, of Hipaa. It refers to health plans, health care clearinghouses, and providers of health care that transmit certain information electronically, which is just about all of them. So the business associates are then covered in a derivative sense in that they are business associates that assist the covered entity to help it carry out its healthcare functions. And we'll see this as somewhat of a trend as controllers, processors, as these regulations are going on. Not only are these regulations covering the primary entity that is the target, but it has to make sure it captures the subcontractors, the vendors, the business associates that are engaged to handle, process, or receive this information. But business associates, not only under Hipaa, but under all of these regulations, need to be aware that it's not a risk-free deal for them because many of these regulations have direct liability for the vendors or subcontractors if they don't meet certain of these requirements. Then we have the GLBA. The GLBA, of course, is a financial specific regulation. Most people in this room probably understand the ramifications of it because privacy is a very small part of the GLBA. But essentially, it repealed the Glass-Steagall Act, which had previously segregated the roles of commercial banking, investment banking, and insurance. And due to a lot of kind of political leanings and the Citigroup merger in 1998, the writing was on the wall that it was going to get repealed, and that did happen, obviously, in 1999 through the GLBA. But for the purposes of us today, the GLBA had the foresight to look at if all of these financial institutions are going to be merging, what's going to happen with the data that they each separately have that is then being combined into these merged and joint entities. And the response was to create a few different rules. The financial privacy rule, which requires that you do an initial notice to a consumer about your privacy policy and an opt-in, opt-out provision, as well as an annual notice thereafter. The notice has to have very specific things in it, what data is collected, where the information is shared, how the information is used, how the information is protected, and that the consumer has the right to opt out of the information being shared with unaffiliated parties. Anytime you change your policy, there needs to be a new notice that goes out with a new opt-out option given to the consumer. So that is the financial privacy rule, which, again, the distinction I made, that goes to the privacy side of things. The cybersecurity side of things is spoken to by the safeguards rule, which requires, first and foremost, a written info security plan. You will see that the base level of compliance with any regulation is generally going to be you need to have a written plan. And we'll circle back around to that in a little more detail in the takeaways conclusion of this section. But this written plan needs to have a designated employee who's responsible and accountable. It needs to allow for risk analysis of potential data threats, breach threats, all of those things, and it needs to provide for means and methods to develop, monitor, and test the written information security program that you have in place. And finally, not just with this regulation, but again kind of throughout, the plan needs to be flexible in the sense that it is constantly reviewed, amended, and policies in place to make sure that this is regularly done. And then the third rule that they did, which goes back towards the concern that I had said before with these entities merging, is the pretexting prohibition rule, which is exactly what it sounds like. You cannot go out and tell someone, I'm collecting your data for purpose X, and then use it for purpose Y. Simple concept, but that was a key addition to the GLBA based on the underlying framework and ramifications of the entities. Moving on to the GDPR, which probably, again, not because it relates specifically to financial industry, but just because of the sheer amount of press and fear-mongering that's kind of gone on with the GDPR. Everyone's probably heard of it. It is motivated, depending on how cynical you are, either by the EU being a forward-looking privacy regime, right? Or because they didn't like the kind of dominance in the presence of Silicon Valley and the US-based tech companies and social media companies and the way they were leveraging and using big data, especially of EU subjects and citizens. They thought that they should have control and protect those data subjects. It is not only the most fundamental rewrite of the EU data protection law, but really changes the landscape and how we need to look at data privacy, because it doesn't apply just in the EU, and I'll get to that in just a minute. There is a bit of a federalism note to the GDPR in that you have these quote-unquote federal or EU-wide policies that must be followed and regulations that must be followed, but you also have certain things that are left to various of the EU member states. So depending on what EU member states that you are operating in or established in or selling and providing services to, different rules could apply. And this is everything from freedom of press and how it interacts, certain religious activities and how it interacts. So you need to be aware not just of the GDPR and the kind of federal EU sense, but also the localized context and what the member state countries have done since the regulation was passed to apply certain standards. I think the most unanimous thing I can hear about GDPR is everyone has something that they hate about it, right? Very few people think it's a great regulation and is the end-all be-all. It's very, very expansive, more so than any other privacy regulation out there. It's incredibly vague and leaves a lot of room for questions. And finally, it's scary. This is one of the reasons that you've heard about it, right? There's been tons of privacy regulations, but this one everyone has heard of. It's been in the news because of the fines that are possible under the GDPR. It has a max fine of 4% of global annual revenue, or 20 million euros, whichever is greater. So it's a serious regulation. You need to be aware of it. Obviously, the saying was before it got enacted in the summer of this year is that no one will be compliant with GDPR at the deadline. And I think that just about everyone was in agreement that it was so vague and so massive that that was the case. But because of how the fines are tiered and how they work, some compliance is better than no compliance. So don't let the daunting sort of big scope of the regulation keep you from doing something, because that's the worst thing you can do is nothing. The scope of the GDPR that I've referenced a few times is kind of a three-pronged test. The first is if you are an establishment in the EU. There's two categories of being an established EU presence that you can have. One is as a controller, the other is as a processor. And all of this ties back down to the definition of processing data, which is incredibly broad. Processing data under the GDPR is essentially any holding, collection, transfer, use, analysis, you name it, of data, of a data subject. Anyone who does that with any of that data is a processor. Whenever they do it for a controller who controls the means and use of the processing. So you see the equivalent of GDPR here of the Hipaa covered entity and business associates. The controller is essentially the covered entity that controls the means and the use of the processing, whereas the processor is similar to the business associate, that is the subcontractor, the vendor, the service provider generally. Although, of course, a processor can be a controller as well. They're not mutually exclusive in their definitions. The second way that you can be covered by the GDPR, if you don't have an establishment, and under this first prong, if you have an establishment in the EU, the location you're actually processing the data is irrelevant. So if you are a subcontractor for an EU controller, you need to watch out. If you are if you have a branch of your company in the EU, you can't just ship the data somewhere else and process it. There's a lot more reasons you can't do that as well. But the location here doesn't matter. If you have an establishment in the EU, you're covered. And the second prong, it's about whether you are selling goods or services to the EU. There is not incredibly clear guidance on this, in the sense that they say they take a holistic view, essentially, of whether or not the entity envisions offering goods and services to the EU. And they list things that are not in and of themselves, dispositive, but that do or could have an effect or could be dispositive, depending on the circumstances. The language that you market in, if it's an EU member country language, if it is, if your website has certain languages that seem to be directed towards EU member countries. Domain names, if you have a domain name that is associated with a specific EU member country. If you accept or deal in currencies that are associated with the EU or EU member countries. And if you make or receive deliveries, which is probably one of the most basic ones, right? If you're making deliveries to the EU, you're likely offering goods and services. Then the third would be organizations that monitor the personal data of EU residents. And this is where we really get back to the tech company and the social media, but it applies far beyond that, because tons of apps these days, any sort of, a lot of website functionality, even if your website isn't geared towards the EU, is still going to track information through cookies and other things of those who visit the website. And the location is relevant under this prong, which is one of the only kind of saving graces of this prong, because it's only relevant about EU subjects as it pertains to their behavior in the EU. If they're just here for tourism and the tracking happens entirely while they're here in the US, but it does not continue to track them whenever they return, arguably it's not going to be covered by the GDPR. The drafting of this provision, as well as many things in the GDPR, is incredibly broad. People think that enforcement is going to be difficult for some of these very broad provisions for jurisdictional purposes and everything else. But regardless, the threat is there, the concern is there, and you need to be aware of it, even if you make the informed decision not to act based on that knowledge. And I kind of put the GDPR there first because although it's not a U.S. federal regulation, it is federal in scope as far as the EU is concerned and the global ramifications it has. The New York Department of Financial Services is a more localized legislation or regulation, and it took effect just last year. I think as opposed to the breadth and the vagaries of the GDPR, I'm actually a pretty big fan of a lot of the New York Department of Financial Services and the way they tier out the deadlines and have limited exceptions based on your size, based on your organization. And every 6 months they had a new rollout period. And I think, you see there 3.1, I think 9.1 was one of the final cutoffs. And if you look at the chart that I handed you, that's going to be the cheat sheet. If we have time, then I'd like to go through that towards the end, because I think that really gives you a clear grasp of the timeline. It sets out for you if you were going to undertake a compliance project, regardless of whether it's specifically intended for the DFS compliance or not. It really provides a great roadmap of the steps you need to be taking. And if you are a small organization that wants to do compliance light, right, then look to the limited exemptions to see, oh, I don't need to do this, 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 and this. Now, you may need to do those, but again, doing nothing is the worst option you can take. So I really think that the cheat sheet for the New York DFS is a good guide as a starting place if you're trying to wrap your head around what steps you need to take for your info security policy and program. But the scope of the DFS is any person or entity operating under or required to operate under a license, registration, or other authorization under the New York banking law, New York insurance laws, or financial services laws. I'm not going to go through the entire list, but you can see the big list of companies here. Now, obviously, New York, although it's a local regulation, this is very important to take note of regardless, just because of the impact and the effect New York has on all of the financial markets of the world. Further, the NAIC, which promulgates insurance-based regulation, they make model policy recommendations, and their goal is once they kind of promulgate the policy and finalize it, within 3 years they try to get all these states to adopt those insurance legislations or regulations, or at least most of them, and they're generally very successful at doing this. They were working on a privacy cybersecurity regulation for the insurance industry for 2 years. And whenever the New York DFS Part 500 came out, they pretty much scrapped it entirely and said, we're going to go with that, right? So they took the New York DFS, kind of repurposed it into a lot of the insurance language and model, and many major themes of the DFS became the NAIC model. The application of the NAIC model is very interesting because there's kind of a theme going right now that the new California state legislation, which is very prevalent right now for multiple reasons, there's thoughts that that is going to become the new mini GDPR that various states apply. And I think that we're going to see that there's going to be the NAIC doesn't have to apply just in the insurance context. I think that there's going to be kind of a battle between state legislators over whether the Gdpr / California type legislation is the best, or if you're going to see the NAIC model take over. And until that happens, that fight kind of happens and we have some sort of uniformity, hopefully, because we may never have uniformity, we need to be aware of all of the various state cybersecurity breach notification laws that are out there. As of March of this year, all 50 states, as well as DC, Puerto Rico, Guam, and the Virgin Islands, all have breach notification laws, which means that if you have a breach, and what is a breach, right? Well, it depends on the regulation that you're looking at or the legislation, because they all define them differently. But if you have an incident that could be considered a breach, you need to be familiar with what laws, what state laws could apply to you, as well as all the federal laws that we just discussed, because you have to notify based on your obligations to those states. So if you're operating in Texas and there's a notification law that says you have a certain amount of time, and then you turn and say, well, Missouri law, so I don't know what Missouri law says, but you have 72 hours. Well, if you're just following Texas law and you're not paying attention to the Missouri law, then you're going to be in violation of that law as well as maybe 5 other states. So you really need to be familiar, and this will tie into breach response and some steps you can take to be prepared for these situations. No surprise, the first privacy law was California, or breach notification law was California in 2002. So think about what that means. That means that from 2002 until March of this year, we went from having no breach notification laws to every state and territory having a breach notification law. The pace that this is in, I could put up a dozen states that just in 2017 altered or enhanced their breach notification law in some way. So this is evolving very, very quickly. You need to have vendors and professionals that can assist you whenever things go south, right? The common themes among these state laws are that you need to provide notification to affected state residents without unreasonable delay, and that's vague for a reason. Notification of state agencies, attorney generals generally, as well as consumer reporting agencies. Notification exceptions are in some of these policies for good faith access by an employee of your company. If you encrypt the data, and if you don't read too much into this one, because again, this is only some of the regulations, but if there's a determination made that there is a low risk of harm from the incident or breach, sometimes that can be exempted from the need to notify the consumers. The states, some of them have specific notification content requirements. So if you are breached, you have to notify the consumer of X, Y, and Z in specific language that needs to be provided. And then civil penalties enforced by the state AG are pretty ubiquitous throughout. The private causes of action, which you see here, are more limited at this time, but the trend is to start adding in some of these private causes of action and statutory penalties that are enforced through a private cause of action. So again, some of the key differences that you need to look for in the various states, or your attorney or your notice provider, whoever it may be, needs to look for, is when is notification required? Again, some of these regulations are vastly different on from a time standpoint from others. And if you are a large national company operating in multiple states, you really kind of have to play to the lowest common denominator of the regulation, and you have to say, well, the most stringent one is this. I need to go ahead and comply with that, and because of efficiencies of scale, if you're complying and sending out notices and that, you're probably better off just doing it that way for most of the states, assuming that in itself doesn't violate some sort of regulation. The resident thresholds are in some of these, which means that if you affect 500 consumers, then it's a breach. If you affect 499, maybe it's not. Not all states have that, so you need to look for what sort of thresholds there are on the consumers that are affected. The unreasonable delay, vague term that I said before, every state believes this kind of means something different and gives a different guidance on timeline, or doesn't give a specific guidance on timeline and just says without unreasonable delay. And then again, AG versus the private cause of action, I've mentioned multiple times. And I already kind of hit on this, but you have to understand that this pace at which this is all changing is incredible. The recent expansions, I said that a lot of states had amended or enhanced their breach notification laws. Well, personal information, which generally speaking, you have to have a specific protected class of information before you're even concerned, right? If it's not a personal type of information, then it's not going to be a breach or an incident if that is accessed, most likely. And so if you look, Illinois, Oregon, Rhode Island, South Dakota, New Mexico, Alabama, they've all somewhat recently expanded their personal information terms to include, they're not all the same for all of them, but combined, health insurance information, medical information, biometric information, which can be anything from eye scans, your fingerprint scan, facial recognition software. These things are now specifically identified. So one of the big fights that Facebook has been in lately is whenever you get tagged in a photo, right? Well, there is a processing in an algorithm where Facebook then says, well, these people have been tagged in prior photos. We think that they're also in these photos. Well, and how does it do that? It's because it's processing data that suggests that this is what your, it's facial recognition software essentially. And so that is a form of processing. And so, but is it personal information for the photo itself that's publicly posted? Not really, but the underlying data that forms your facial recognition, there's fights going on under various laws about whether or not that is personal information that can be processed without your consent. So there's a lot of nuances within these, and biometric information is a whole presentation in and of itself, so we can't go down that trail. But then we also see in California, Florida, Alabama, Illinois, all of the states listed here, that now the compromise of a consumer or individual's username or email address combined with the password requires notice. To me, that seems like one of the most obvious ones, but I guess prior to this, this sort of sea change, that wasn't necessarily included in personal information. Now we're going to get to the California law. This is saving the best for last. The mini GDPR is what it's being called. The passage of this is really interesting. California has a ballot initiative where private citizens can submit laws for vote on a ballot, right? And the catch here is that if a law is passed this way, it has to be amended by a supermajority of the legislative body as opposed to a simple majority that most laws can be passed under. So what happened here is some private benefactors decided they were going to get a ballot privacy law of essentially mini GDPR passed. And the legislature realized if they accomplished this, and they were spending significant resources to get it done, then we won't be able to amend it freely to make it make sense and fit within what we want to do. So these private benefactors essentially said, well, we'll take it down if you agree to pass a regulation by X date in the private, and they agreed to it. So they leveraged through this private ballot initiative getting something passed by a June 28th deadline. So this bill was introduced on the 22nd. About a week later, it was passed, and it was a pass first, ask questions later, because they said, at least we can amend it if we do it this way. So really interesting system they have. But the scope here is a little more generous than the GDPR. For-profit entities doing business in California or any same branded subsidiary with revenue greater than 25 million, or that receives or shares personal information for greater than 50,000 either consumers, households, or devices, which is interesting because the devices is going to get hit way before the individuals is in most instances. Households is interesting as well for other reasons. Or if you receive greater than 50% of your revenue from the sale of the personal information. So those are how you can be captured by the California state regulation. There's a whole lot of concerns with this regulation, including the devices thing that I mentioned, the definition of consumer, which under the original includes employee data. In a very broad sense, that would be prohibitive for a lot of companies. Again, particular consumer or household, whenever you tie the definition of information to household, it encompasses more things generally than just the individual, because there's a lot of things where you could narrow it down to a household that you may not be able to narrow it down to the individual, because multiple individuals could be using various computers or anything else within the household. And then again, the unique identifiers and IP addresses that's highlighted there below is also a bit unique. IP addresses under a lot of, or not a lot, under GDPR at least, is generally covered, but the unique device identifiers kind of goes towards that household issue as well, that if you can identify the device name, not necessarily the consumer on it, then that's going to be covered. The compliance date, January 1st, 2020. Penalties for this, up to $7,500 per violation, per intentional violation, or $2,500 per unintentional violation, which is not cured within 30 days. There's also a private right of action. The funds that are collected, similar to GDPR, are then split. Some of them are paid to the consumers, and some of them are then paid towards a privacy fund, essentially funding the government efforts, in this area. And then the other two are just repeats of before. I'm going to skip through these slides because we're kind of running out of time, but also just the general statement that this is not effective till January 1st, 2020. It was passed with the specific intention that it was going to be amended before it takes effect. So I wouldn't focus too much on the nuances and the specific provisions here, other than the general themes that I was talking about before that you need to do, and which I'll hit on again in a second, of getting prepared generally from a compliance standpoint. But as far as the specific provisions of this law, they will change. There's already multiple proposals out there about how they're trying to amend this bill, including the definitions that I was discussing, clarifying when the private action is available, only in the breach context, not in a failure to comply context. Things like that are already in the works to fix a lot of this concerning language. And then just as far as talking about the per incident charges and everything else, as far as the impact, there's kind of allegations out there and claims circulating that the California Attorney General's office received a breach notification almost every day of June 2018. So the amount of breaches that are occurring are very, very substantial. And it doesn't take long, and each breach is not probably going to be a single violation. So the numbers will start to add up quite a bit. I'll skip through some of this, which is the proposed amendments that I just kind of glossed over. And this is what I discussed before. I think in the short term, we're going to see states kind of tweak and alter their stuff to come more in line with one of probably more progressive states, the California model versus the kind of NAIC model. I think is going to expand beyond just the insurance context, or the New York DFS model, if you want to refer to it that way. And then in the long term, there's already been multiple federal regulations and bills that are kind of being tossed around from various camps, because I think there's finally hit a critical mass of understanding that a federal regulation, as much as we may not be fans of regulation, may be far better than the 54 piecemeal notification requirements that we have now. I think in the long term we will see a federal regulation, but whether that's 3 years or 10 years, who knows. A few takeaways and action items to keep in mind. Many requirements are tied to reasonableness, which is terrible in the sense that it doesn't give you clear guidance, but can be useful in the sense that if you're a smaller organization, there are still steps that you can take that could get you to where you need to be. Many penalties are tied to the severity of the neglect, which again is why doing nothing is the worst thing you can do. And then full compliance is always the goal, but at the very least you need to do something. You need to show that you have a written policy and plan in place. You need to show that you've taken specific actions towards compliance, even if you haven't reached compliance whenever something happens. You can take steps to train employees regularly on data security. This doesn't have to be an incredibly intensive process, but can be something as simple as what we're doing here today, once or twice a year, or phishing exercises get a bad kind of rap, but it's still better than nothing. And then you have regular data security assessments. You need to have mapped out your IT structure and understand the risks that your company faces. And this should tie into, each of these things should just be built into your written ISP. You need to have the information security program setting out, here's how often we train our employees. Here's how we do our regular data assessments. Here's how we do our risk assessments. Here's how often we do pen testing if you get to that level. And then, getting to the more advanced stages, hopefully you'll be running tabletop security exercises, which gets into the breach side of things, which I'm going to talk to in just a second. And so the last one does as well, discussing the breach response, vendor, and notice issues, at least internally within your company, but preferably externally as well. We see a lot of companies that will do internal fire drills on these data breach issues and everything else, but they don't involve their outside counsel, they don't involve their outside vendors. So if they're just doing a internal only, one email address was accessed that wasn't a very important email address, and maybe these 5 key documents got out, something like that, sure, you'll handle that internally. But if there's a larger than that incident that could rise to the level of breach, or you don't know if it's a breach, you're hopefully going to immediately start contacting your outside counsel, who's going to contact your forensics vendors and all that stuff. Well, if you haven't set that up in advance, then all of a sudden these internal drills you've done for crisis management and breach response go out the window, because your internal people aren't necessarily running the show anymore, and you don't necessarily want them to be running the show anymore. So you really need to think about how you can engage your outside vendors in a prophylactic way. And I'll talk a few more details later, but some of the top mistakes we see are delays in acting. And this isn't necessarily intentional. It could just be a lack of acknowledgement about the scope of the problem, or just a lack of knowledge about what the incident scope is. And we see with the forensic side of things, once they get in there, every day matters on the forensic side of things. You have logs, you have temporary files, you have all these things that are constantly churning through your system. And whether it's a ransomware attack or a unauthorized access issue, whenever they get in there, it makes a big difference whether they get in there 24 hours later versus 72 hours later versus 7 days later. The information they can access, their ability to investigate is much better the quicker you can get them on site. Not knowing who to call when something happens, and this goes on to the internally focused side as well. Just think, who is your favorite scapegoat? And I don't mean your brother or your sister, I mean, who's your favorite scapegoat that has malpractice insurance and credentials that you can point to and say, I handled it the way they told me to handle it? It's your outside counsel who you trust, who you've talked to these things through with. And the next thing we see is the people who you call, preferably your outside counsel, not knowing who to call. And this isn't because they don't have the context, it's because this is the first time you've called them about data security and privacy issues. And they need to know how your system operates, who the key people are in your organization from an IT data standpoint, what vendors you prefer for various things, what vendors you've used for your consulting, IT consulting, those types of things. They need to generally understand the mapping of your organization so that whenever the breach happens, they hit the ground, they already have MSAs in place with vendors that you all have talked through and you've approved, and so everything runs seamlessly as soon as something happens. And then finally, this as a litigator, this is the thing that I just cringe about all the time, and that's privilege concerns. You need to take affirmative steps whenever you realize there's an issue to do what you can. Privilege is not a magic wand that you go around and just apply to whatever you want because your counsel is CC'd on it, right? So you need to understand the first thing is get the counsel involved ASAP, because your counsel should be advising you on the steps you can do to maximize your odds of being able to claim privilege towards items. And I say maximize because you should never expect to guarantee that privilege is going to protect your document or your item. You can just maximize your chances and prepare yourself for the fight over that privileged document. You should have incident response counsel. I'm not sure what that word's supposed to be. Retain and direct the work of other response vendors. Because obviously how you would generally set it up is you want your outside counsel to be retained by you, and then your outside counsel retains the vendors that are going to be providing services to you throughout the breach response, so that you have the flow through, maximizing your odds of privilege through the engagement with counsel. And you want the engagement letters to state a specific purpose. The purpose of your, this is a terrible example because it's really hard with PR firms, but the purpose of your PR firm is not to protect the business reputation through crafting communications. It's to assist your legal team with providing legal advice, and depending on the circumstances, could be in anticipation of litigation. You should also consider there's some case law that's gone around, and me and a colleague of mine wrote an article about this, specifically about data breach context and how to preserve privileges. And you should really consider having two separate parallel investigations. One is going to be the investigation that informs your business side about what happened, how it happened, kind of the factual underlying stuff and how we can fix it. And then you have the litigation side of thing that's in anticipation of litigation, provides a lot of legal analysis, explains a lot of the risks involved with what happened, and whenever you do that, you can then separate and easily classify the documents that you have created in one arm versus the other as being privileged versus not privileged. And there's some case law that suggests that if you combine these two roles, you could have concerns. So if you have one firm that's both preparing your, saying that they're preparing litigation advice, but then is also directing one of the breach response teams, and the breach response investigation is reporting up through them, then a lot of those reports that those vendors, even though they were engaged by a lawyer and everything else, are not going to be privileged because the information they're providing was really through the investigative business unit route. And then finally, develop a coherent strategy about internal and external information sharing. You need to know who is getting what information. It's traditional crisis management. Who's getting the information? How are they going to get the information? And why do they need it? You need to have a defensible reason as to why this person needs the information they're receiving. Especially in a breach context, a lot of this stuff you want to keep as internal as possible, except for your reporting requirements, obviously, so that you can manage it without having to worry about all of the PR aspects and everything else immediately. Then parting gifts. I already mentioned the cheat sheets. The New York DFS is in front of you. I have another one, like I said, that's substantially longer, but I'm happily to provide it to whoever would like it. There's cards at the end of each of the tables at least. I have a stack of them as well if you want one. I don't know how much time we have for questions, but here's an example of the New York Department of Financial Services. And then here's the first 2 pages of the Hipaa, DFS, Gdpr chart. Well, first 1 page, I guess. Thank you all. If you have questions, I can stick around and ask them. I think we're probably short on time as far as about 10 minutes. Okay, well, I'm happy to answer questions, and thank you again.
So if you have questions for him, you can stay around. So as long as you're out for like 9:20, 9:30, you should be okay getting out. We have several more Aspire events coming up. There'll be emails going out about the one that's going to be on October 10th. Please make sure if you haven't signed in that you sign to check in with the desk before you head out. They'll have CPE certificates there. If we don't have your information in the database, please make sure that you leave a business card so that we can get your information, so that you get the emails about the future Aspire events. I want to thank Brandan, I want to thank Becky for coming out, and thank you all for coming and attending today. So we hope to see you at more events in the future.
Thank you.